NACDL is the association of the nation's criminal defense bar.
For those of you who are unfamiliar with EFF, the Electronic Frontier Foundation, we're a nonprofit based in San Francisco that works at the intersection of law and technology. We do a bunch of litigation, legislation advocacy, and grassroots organizing, as well as technological innovation trying to protect digital liberties in the digital world. So let's get started. First, we wanted to basically demystify some basic concepts about artificial intelligence. This is not something that is inaccessible to you. It's not something that's pie in the sky. When we talk about artificial intelligence, what we're talking about is a field of computer science that focuses on getting computers to do tasks that normally would have been done by human beings. And so often when we call a thing AI, we call it that only until it becomes commonplace. Just 20 years ago, we might have called a simple internet search AI. Now we have commonplace terms like Googling or to do things like that. So artificial intelligence just means we're automating something that traditionally was done by a human being. Algorithmic tools are basically an algorithm that's used to make a decision I realize I'm going forward and not going forward for you guys, is an algorithm used to make a decision to provide information to a human decision maker. An algorithm tool can be as simple as fill out a questionnaire, count the number of yes answers. If greater than some threshold, do X. Otherwise, do Y. In other words, for a tool to be algorithmic, you don't necessarily need a computer. The Arnold Foundation's public safety assessment is an algorithmic tool that's used to conduct pretrial risk assessments, but it doesn't necessarily, you don't actually need a computer to do the calculations for the PSA. Then machine learning. This is a particular sub-area of AI that also incorporates techniques from statistics, in which a computer program actually learns from existing data in order to produce some desired output. So the computer is basically told to take an action in response to some kind of input data, or predict some kind of outcome. Not all AI uses machine learning, but machine learning is probably going to be the most popular subfield of AI. So let's talk about what machine learning and AI mean in an analogy. Assume an engineer might code a program that's meant to detect the difference between dogs and wolves. The program would be provided a set of training data, photos known to be dogs and a set of photos known to be wolves. Then the system would be provided a new set of photos, different from the training set, and asked to determine whether each photo was a dog or a wolf. And to the designer's delights, the program correctly identifies wolves and dogs with about 98% accuracy. So we're really excited about that. But when you look at, when the engineer actually goes back and evaluates how the program made that determination, it may reveal some surprising insights about the future accuracy of the program. Sometimes programs will rely on unintended factors as proxies for the decision it's asked to make. So for example, if it turns out that the program made the determination of dog versus wolf solely on the basis of whether or not there was snow in the background, then the program isn't actually doing what it was asked to do, learn the subtle physiological differences between dogs and wolves, but it's relying on a much easier to track factor as a proxy. So machine learning, ultimately, like human beings, is lazy. It wants an easy proxy. It can, if it looks and it sees that there's another factor that correlates with what the desired distinction is, like race or zip code, it's going to rely on that. And a tool that's trained on one set of data might be useless on another set of data. For example, the dog and wolves in summer. It would be very difficult for that algorithm to successfully do what it was designed to do. Then, so source code review, I mean, we tend to talk about the importance of getting the source code. That's not where the inquiry should end, because source code review wouldn't actually have necessarily have spotted that issue with the dog-wolf analysis. So we're going to talk about a bunch of examples of AI today, which I'll cover. And then Rashida's going to go over the public policy concerns and in context, so you understand kind of what are the problems that these tools are facing. And then finally, Andrea's going to go over litigating cases with AI-generated evidence. So examples of AI in the justice system. We have algorithms that decide the number of hours for in-home medical care, for deciding if a child is so at risk that CPS should open an investigation, to decide if someone should get welfare benefits, or even to decide if who should we release or detain. And here in California, we actually have Senate Bill 10, which just passed this past election season. It may not go into effect until 2020, but there, the state of California is going to be required to actually implement a pretrial risk assessment in every county. And there are a number of problems with the implementation of that, or even if risk assessment tools should properly be used, and hopefully we'll go over some of those issues. They're also used to decide who committed a crime, such as in probabilistic genotyping programs. So there, when DNA samples are too degraded or there are multiple contributors, there's not actually a single contributor, rather than say, okay, the evidence is inconclusive, it's fed into a program that then makes determinations about probabilities on who might be the primary contributor. And then finally, we have predictive policing programs that decide who will commit a crime in the future. And I think for the most part, what we've come, those of us that have been looking at these programs that are being deployed in the criminal justice system, these kinds of predictive programs that are meant to predict what someone will do based on what a group of people have done in the past is precisely the type of reasoning that we have traditionally kept out of the criminal justice system. That's why we have a ban on character evidence and things of that nature. It really is very difficult for these programs to be properly trained, because the true data set that would have revealed that would have been necessary to train them properly just doesn't exist. And nor do we think it will likely be found. And Rashida will talk about why.
So, oh no, there's one more.
Oh, sorry. And so what's the basic problem? You have prosecutors saying, all right, your client's guilty, some technologically produced evidence links them to some scene, weapon, crime, what have you. Why, you ask, why do you think that? How did you arrive at that conclusion? And they say, well, it's a secret. We're not going to tell you because we either don't have it or it's protected by the company's trade secret. And so that's the basic problem at getting to a lot of the materials around these algorithms that are being used.
So there's a number of public policy concerns with the use of algorithmic systems in the criminal justice system, and some of the concerns that I'm going to go through are more technical, but I wanted to state as an overall issue, there's an ongoing debate about the use of these systems, and then just whether they should be used in a broken criminal justice system, because some of the problems that I'm raising are, in fact, the system just working as it should with technology placed on top to gloss over what's happening. So the first is automation bias, and I think that this stems from more of a societal problem of us thinking just because a machine is doing it or just because something is based on data, it's therefore more objective than a human or a judge who's using intuition or other non-scientific or subjective factors to make a decision. When in fact, a lot of the times there's problems with the data, or even when these systems are developed, there's a lot of value judgments and subjective determinations that are going into how the system's designed and how it ultimately performs. So we end up with both us as society, but also a lot of decision makers within the criminal justice system, assuming if we use these tools, it will be fairer, but in fact, they either amplify or exacerbate a lot of the existing issues. There's also a lot of data problems, and in fact, I would suggest that many of the problems with these systems stem from data issues. You either have incomplete data sets or incorrect data, and that's in part because a lot of these systems are using government data, and as we all know, police officers and a lot of government officials are not necessarily data scientists and trained in collecting information that is ultimately used in these systems. And then there's also not a lot of oversight or accountability in how this information is then handed over to third-party vendors or to developers within government creating these systems to check for problems. So one example I'll give is going back to the example that Stephanie mentioned with predictive policing. You have two main types of predictive policing. You have place-based, which is predicting whether a time will occur in a certain time period in a geographic region, and then person-based, which is assessing whether particular people are going to be a victim or a perpetrator of a crime. And in a lot of these systems, they're relying on police data and crime data, and it results in what will probably, which is the next issue, which is bias issues, in that if you have a police department that historically has targeted certain neighborhoods or certain groups of people, then those groups are going to be overrepresented in the data, which will result in the system producing predictions that says this geographic area or these types of people are more likely to commit crimes, when it's really that it's just producing problems that were created by the practices that generated that data. And that leads to some of the disparate impact and bias issues, in that you have these either overrepresentations or misrepresentations within the data, which are then projected by the systems. Another thing, and this is a more technical thing that comes up in a lot of debates around the research, is fairness metrics. There's over 19 definitions for fairness. And these are like technical definitions, so they're more focused on quantitative measures rather than like qualitatives of like, do we respect the humanity of this individual? And the problem with a lot of these fairness metrics or the fairness definitions and metrics is sometimes they're in conflict with one another. So I don't know if some of you are aware of the ProPublica series, Machine Bias, where they explored some of the problems with Compass, but that was an example where ProPublica was saying this tool is creating racially disproportionate outcomes, and Northpoint, which is the vendor of Compass, was like, no, it's fair. And if you look through the footnotes of like the series of articles and court documents that resulted from that series, it's because Northpoint and ProPublica were actually using different definitions of fairness. And so both of them technically were right, but they were just not using the same definition, which is one of the problems. And then another problem is you can have fairness definitions that are incompatible with accuracy. And a lot of the times, none of this information is available to the public or even to the decision makers that are making this. So you could have a system that a vendor or even the marketing materials will say is fair, is just, but in fact, if you dig a little deeper, which we'll go into when I explain like what you should be asking for and why, you'll realize that it sometimes is this sort of, we're using two definitions, or sometimes they're just in conflict with different values. And then these last two I'm going to put together because they're related, in that the procurement of these systems are often very opaque. You have some systems like the Arnold Foundation's risk assessment tool, which is given for free, so it may not go through a normal procurement process, or some vendors whose business models completely rely on government contracts may give in-kind gifts or free services just to get entry into the market. And again, those won't go through the normal procurement processes. So often opportunities for public input or even awareness from other government officials is not happening. And then the other problem with procurement is often the procurement officers who are contracting with vendors to secure these tools are not that informed about what they actually do, so they often give up too much in the negotiations. Two common problems are, first, that a lot of the contracts, and this is a term that's used by Palantir a lot, which is a data analytics firm, is that they'll state that all data generated by the system is owned by Palantir. And that's traditional language that's used in a lot of software programs, so it's something that if you're a procurement officer that's been procuring stuff for an agency for 20 years, you're like, that's normal language, I don't need to look into it. But the problem is that with these systems, since they're data-based and often relying on government data, that ends up meaning that the government data that's going into these systems to create the either predictions or risk assessment scores ultimately becomes owned by the vendor. And that's what allows these vendors to make very broad trade secrecy and other IP claims, in that so you can have a vendor saying, actually everything related to this system is a trade secret, therefore I don't have to reveal it, and it's in part because of these broad contract terms that are being ignored. And then the second, and this is more common with smaller offices, is that the government agency, whether it's the police department or your local criminal justice services or office or court administration, relies too heavily on the vendor. So they'll store all the data with the vendor. They'll make sure that the vendor's doing all the servicing on the system. So then when it comes to challenging these systems, that agency will be like, oh, we don't actually have access to anything, so we can't comply with your subpoena, or we can't comply with your public records request. Which creates a lot of issues. So you may wonder, okay, these are a lot of problems, so how do I find out about these systems? Some, like Stephanie mentioned, like the risk assessment that will be developed in California as a result of the SB 10 law that passed earlier this year, are dictated by law, and that's more common with some of the pretrial and sentencing risk assessments, in that you'll see a request for a proposal or some type of legislation. A lot of the times it's fairly vague in what it's saying that the system should do, so you still may not know what type of system it is. But overall, a lot of these systems are fairly opaque, especially those used by law enforcement, which creates a problem in figuring out about their use. So even though this isn't the best advice, I would say a lot of the times you have to lead with some skepticism and probably apply some of the tactics that were discussed in yesterday's panel about parallel construction, because you see a lot of the issues that were discussed during that panel happening with the use of these algorithmic systems, in that you can have a system, and I'll use an example of in New Orleans, they were using Palantir's predictive policing system to help address gun and violent crimes, and there it was being used to target who may be a member of a gang. And then later, an attorney, after there was a series of articles in The Verge about the opacity of the both acquisition and implementation of the system, and the fact that a lot of government officials didn't know about it, and a defense attorney made a successful Brady challenge about the non-disclosure of the Palantir system, because his client was actually targeted by the predictive policing system, saying that he was a gang member, but none of that was actually disclosed or known until the series of articles came out. Again, a lot of the times you kind of have to ask questions about how did they actually find out about my client, or how was this information available, and a lot of the times it will stem back to some type of algorithmic system. And your main two mechanisms for getting information is probably a public records request and then through discovery. And I'm going to go through what you should ask for, explaining some of these terms before handing it over to Andrea, who will give you more practical advice on how to actually litigate. And apologies in advance that I'm going to go out of order because I realize I want to explain some things in context. So I know we've used the term source code. So what is actually source code? Because that is something you would want to ask for. That's typically the instructions that a developer creates to create a program. And then a model is often the mathematical model or statistical model that is used to produce a certain outcome or perform a task in these systems. And you'd also want to know that to understand how these systems work. And in more machine learning-based systems, the model functions more as dictating the relationships and the rules that a system has to learn to perform an outcome. So if we're using the example of the wolves and dogs earlier, it's saying like, or I don't even know how to tell the term, or like what, but it would create some rules or boundaries saying like, a wolf has hair this long. This is really, I'll just stop, but there will be rules and relationships that the system would then ultimately understand to distinguish the difference between a dog and a wolf way better than clearly I can. You also want to ask for the executable program because this allows you to see how the source code or the program runs. And getting access to this type of technical information not only allows you to see how does the system work, but also interrogate it to figure out what are the problems and how did it possibly harm or target your client. Next, you'll want developer or operation documents, and these are sort of the notes that is taken by the developer when they're creating the system, and this can also include training manuals and other documents that are meant for the end user. So if that means it's a probation officer who's going through their questionnaire to then input it in the system to produce a risk assessment score, then the training manual that person would get telling them what questions to ask and how to input it in the system may vary from things that were used to develop the system, and it's these types of inconsistencies that may help you illuminate some issues. Next are the testing plans and results, and this is something. These types of plans exist throughout the life cycle of a system. So as a system is being developed or trained and then ultimately implemented, it's constantly being checked for accuracy. Is it actually producing the risk score that it should? And my skepticism will show in the should part. Or whether there's bias in the system or whether it's bugs, because again, a lot of these systems are software-based, and you'd want to see how the developer not only identified these issues, but how were they addressed or possibly not addressed, because that could also affect the accuracy and outcomes of the system. Next, even though 4 says a lot of different things, you're asking for a lot of different data. So you want the training data. That's the data that was used to train the system, so that way it will produce outcomes at a certain accuracy rate. You want the input data, so this is the information that's being put into the system to create the outcomes. So I'll go back to the predictive policing example. If that means the arrest data from the last 3 years, that could be one input variable, and you'd want to know that, especially if you're in a jurisdiction that has a police department that's known for discriminatory practices or targeting certain neighborhoods and people, because then you can make arguments about the misrepresentation and overrepresentation issues I mentioned earlier. And then also you would want the outputs of the system to gauge some of these accuracy and bias concerns that I raised earlier. And then last, which seems a little off-putting, but is asking for marketing materials. And this is an important piece because, 1, a lot of these materials are not always public, and 2, it can help you figure out some of these discrepancies in that a system may be marketed for one purpose, but then when you actually look at some of the technical information in this list, you see that it's not actually functioning as marketed. Or another example, to go back to the Compass tool that I mentioned earlier, Compass can be used at many different points throughout the criminal justice system, but if you have a risk assessment tool that was developed for sentencing, but it's actually implemented at pretrial, then there you have a huge issue because you have a different population that this tool was meant to be applied to, and that's meaning people who were actually convicted of a crime being applied to individuals who are merely waiting trial and haven't been convicted of anything. And then that would produce more of a biased outcome in that it's just not being applied to the right population. So sometimes the marketing materials can help illuminate some of the problems I described or help you figure out some of the issues as you interrogate the more technical information.
All right. So you know the vocabulary, you've asked for all the right things, you know in broad strokes why those things are important. So how do you challenge this type of black box evidence at trial? What are the admissibility challenges? And if it comes in, how might you explain to the jury what these problems are and why there might be inaccuracies? So by the way, this is the image that comes up when you Google evil computer, so, okay. But I did first want to note for the record that sometimes you might be on the other side of these admissibility challenges. So when a computer is exonerating your client. So this is what comes up when you say happy computer. So for example, in one recent case in DC, the defense called a computer scientist as an expert to try to show that their client was not the author of a tweet that purported to confess to a murder. So the defense expert actually took 4 machine learning algorithms, trained those algorithms on data sets that included a bunch of tweets indisputably authored by the client and a bunch of tweets undisputedly written by the client's girlfriend, and then ran this on all 4 programs, and the program said it's not the client who wrote the tweets, who wrote the confession tweet. You know, in another example, and so, you know, authorship of small messages. Another example is probabilistic genotyping software that Stephanie mentioned. Sometimes you're going to be using these computer programs to try to argue that the human analyst that the state called didn't get it right. So I just wanted to sort of, it's what we've talked about and what we're about to talk about in terms of what makes a good or a bad algorithm or what causes inaccuracies is also important so that when you are wielding an algorithmic result to try to help your client, you can explain why this is different from the ones that are not as reliable. Okay, so speaking of DNA software, of course there's so many other types of algorithmic proof of guilt at trial. You know, blood alcohol, Google Maps, GPS location data, text analysis. Someday there'll be IBM Watson testifying at competence hearings, I'm sure. But let me just give you a concrete example that I use as sort of a case study as we go through what you might do at trial. So that's DNA software, which you've heard a little bit about, but there are 2 main programs that law enforcement is using right now. One is called True Allele, created by a guy named Mark Perlin, formerly of Carnegie Mellon in Pittsburgh. And the other one is StarMix, a New Zealand company. It was created by John Buckleton. These 2 folks don't get along that well. They tend to say bad things about each other's programs, which can be convenient for you in a Dalbert Fry hearing, I suppose. And this is what the output of the machine is. So this is a program that doesn't just say, we think that your client is a contributor to this mixture, or that this person is a contributor to the mixture. They actually spit out a number, and that number can be highly damning or it can be exonerating, whatever. So it's typically we call it like a match score or a likelihood ratio, but it's basically saying that, you know, it's 420, I can't even see what this one says.
471.
471 million times more
probable.
Thank you. More probable than a coincidental match to an unrelated black person. And they'll thank you. And so they'll give a different match score for different self-identified ethnic categories, for example. That is the printout that you're challenging in court. Let me give you an example of a case where this has sort of come in, and then we'll talk about what to do. So there was a tragic case a couple of years ago in upstate New York involving the strangling of a 12-year-old boy. His suspicion fell upon a couple of ex-boyfriends of his mother, one of whom had a domestic violence past and some classmates of the boy. But ultimately, suspicion fell on another ex-boyfriend who, Oral Hillary, who was the coach of the local soccer team at the local college. So the problem was there was no physical evidence linking Mr. Hillary to this crime, either on the crime scene or Mr. Hillary, but they found some DNA underneath the fingernails of the boy. But it was a degraded mixture, complex mixture. Human analysts couldn't figure it out. So they sent it to one of these programs, TrueAllele. And TrueAllele came back and said, there's no statistical support for the idea that this person is a contributor to this mixture. As far as we can tell, he's not a contributor. So the case fell cold. A new DA was elected on the platform of, let's find this guy's killer. And so they sent it to another computer program, StarMix, who said, oh yeah, this guy's definitely a contributor. You know, there was a very damning likelihood ratio spit out by the computer. And so they tried Mr. Hillary based on the StarMix results. So if you're Mr. Hillary's lawyer and you've got this StarMix printout that's coming in at trial against Mr. Hillary, what do you do? Now, this is a nice case because you can point to the TrueAllele results. You're not always going to have that in a case. So let's say it was just the StarMix results that came in. What do you do? So let me talk about three things. One is Dalbert and Fry reliability-based challenges to admissibility of the software results. The next is putting software results in context for the jury, assuming that they're going to come in. And the third is jury instructions that I think are generally underutilized by defense attorneys as a means of defending against this sort of proof. I also wanted to say, there's also arguments you can make for exclusion, surely based on discovery violations. You asked for the source code, they didn't give it to you. Confrontation clause violation, due process violations. But, if you want to win the trade secrets issue. But for any of those issues, eventually you're going to have to explain to a skeptical judge why it matters that you get that stuff. And so what we're about to talk about is to try to kind of flesh out just a little bit more why it matters to explaining the potential inaccuracies of the results to actually have this information that we've talked about previously. Okay, so let's talk about Dalbert Fry. So what are we talking about? Dalbert is, not all jurisdictions are Dalbert, obviously, but either you're trying to say that this method is reliable and reliably applied, or under Fry that it's generally accepted by the relevant scientific community. If we're talking about Dalbert, we're talking in a scientific method like DNA software. The question is it scientifically valid? And, what does that even mean when we're talking about software? Well, presumably it means you got to show, the government, if they're the proponent, has to show that the software accurately determines what it claims to determine. Okay, so how would you normally show that? By showing it's been validated as accurate through robust testing. That is what, the first Dalbert factor is, has it been tested? But just as a larger point about these admissibility challenges, judges generally just don't want to hear about the boring laundry list of Dalbert factors. The big point here is you've got to get the judge to really be skeptical of this stuff. And that's why it's helpful to know about the result in cases like Hillary. That, look, judge, these programs have disagreed with each other. And so there has to be sort of this aha moment for the judge that goes beyond just the legal test. Okay. So how are you going to, what would normally be the type of testing that you'd want for this sort of software? Well, here are a few examples of testing that you might want to make sure that they have, and if they don't, you could argue that that's a problem. One is a lack of independent industry standard software testing. The second is the lack of sufficient developmental validation showing the accuracy of the output. Like, in other words, validation, foundational validity studies done by the company to just say, look, this model, and the way that it's executed through the program actually works in general. And then internal validation by the lab using the software. Different labs use different equipment and they set different thresholds and different parameters. And so to make sure that StarMix works in the New York State Police Lab, they've got to actually run the program and do internal validation studies to say, look, it works at the thresholds that we're using. And that was actually one of the big issues in the Hillary case, was that it hadn't been validated in New York in this lab. And they used a totally different threshold than what StarMix usually uses. Okay, so let's go back to software testing really briefly. We don't have to guess what robust software testing would look like. We have the Institute of Electrical and Electronic Engineers, IEEE, that promulgates software engineering standards. And they require technically, managerially, and financially independent testing for any software that has a significant social cost, let's say. I'd say that software in a homicide case where your client is facing life in prison is software that has a significant social cost. I would think even a skeptical judge would have to agree with that. So you've got these standards that require way more than simply a validation study done by the company. You would have standards that really stress test this to make sure that it's working, in the same way that the elevator in this building has gone through that exact same testing. And so the beauty of this is, again, to that skeptical judge or jury who otherwise wouldn't care, it's, this person's life is on the line. Don't you at least want the same level of software testing as the elevator in this building has been subject to? Okay. Even if you're in a FRI jurisdiction, you might want to argue to the judge that software engineers, not just computer scientists, not just forensic examiners, DNA analysts, but software engineers are part of the relevant scientific community. I mean, wouldn't you want these nice people to be part of your relevant scientific community? Okay. So then lack of sufficient developmental validation. All of these companies that have this proprietary law enforcement software are going to have a big pile of validation studies. They're going to stick them up on the table. It's going to be this big pile, and they're going to say, see, it's reliable. So let's just break that down for a minute. Were these tests done by someone who is independent of the company or financially independent of the company? Generally, no. And that should be a problem, CEG, the IEEE standards. Are the cases that are done in the validation indicative of the sort of marginal cases that could come up in real casework? In general, dog versus wolf. Is it possible that sometimes this program is going to be asked to figure out dog versus wolf in a situation where there's no snow? Well, that's what we want it validated on, the no snow situations. And so same with, degraded DNA. How does this work on really degraded DNA, not on the easy cases? And what exactly is being validated? So if I can say that the next couple of minutes, if you remember nothing else, the next couple of minutes I think is key to explaining to a skeptical judge why source code is important. So if all we care about is, how often does this program say it's a dog when it's really a wolf? Or how often does this gas chromatograph say that this is cocaine instead of what it really is, which is baking powder? Then we can test that. We test it just like we would in 7th grade science fair. But here's a question. What if the question is, what's my real credit score? Is this credit score of 540 accurate? This African American who's been labeled a credit risk because of their zip code. Are they really a 540? Or are they actually a 720? That's a much more difficult process-related question, not a result-related question that you can't just prove through a validation study. You can't look under a microscope at my credit score and say, son of a gun, she is a 540. So that's why validation studies alone are not good enough to show the accuracy of a computer program that spits out something like a score, because there's no ground truth against which to test it. So here's my favorite quote about it. Lab procedures to measure a physical quantity, such as a concentration, can be validated by showing that the measured concentration consistently lies within the acceptable range. Such validation is infeasible for software aimed at computing something like a likelihood ratio because it has no underlying true value. There are ways to test it, but it's not like the validation study shows that the likelihood ratio is accurate. Okay, so what would you use to show that those types of scores are accurate if you can't just rely on validation studies? Well, judge, you would look at the process itself. You would see what goes into the credit score or the likelihood ratio and see what whether this process makes sense and the software implementing that process doesn't have any errors. So this is what makes software testing and actually looking at the source code all the more important, to see what assumptions underlie this score and to see if they get it right just in the model and also in the way it's actually being executed by the software. There's no other way to do it. You can't just do it through validation. That's why you need the source code. And how else would you otherwise do it? Well, if the government actually went out and got corroboration of the score from another computer program, okay, that might be good. They rarely, if ever, do that. And if they don't do it, that's something you could cross on or point out in a Dalbert challenge. There's a recent study showing that when they stuck in cases to a bunch of different programs, they got different results that significantly differed in terms of likelihood ratio, sometimes even saying, yes, they are a contributor versus no, they're not, which is a big deal. Guilt versus innocent. Okay, lack of internal validation, and then I'll go a little bit more quickly and jump in. But again, I think I've explained the importance of this. Star mix was excluded in the Hillary case on this basis. So they convinced the judge, not that star mix in general is unreliable, but that they hadn't sufficiently validated it for this lab. Okay, putting software results in context for the jury. Ask the computer expert questions. Even with this trade secret stuff, they will often give you the computer program before trial to fiddle with. And so with an expert's help, you can ask them, just like you would a human expert. You know, you depose, you talk to the human expert before trial and you say, well, what about this? What about this? Would it be different if you assumed this? You can do that with a computer. Put in a different number of contributors and see what happens. Put in a different threshold and see what happens. Oh, well, now the likelihood ratio is better for my client. So those are the types of things that with an expert's help, you can do with a computer as well. If they come back and say, look, you've got these people on the witness stand, you've got Mark Perlin on the witness stand, you don't need the source code, that's where you can explain to the judge, this software is so complex, it goes way beyond just what one of these people can tell us in a 2-hour cross-examination. And this is my favorite explanation of this. One of these poems was written by a computer, and one of these poems was written by William Shakespeare. So here's the first one. What's in the brain that ink may character, which hath not figured to thee my true spirit? Number 1. King of hell, no quarrel have I left thee, no lovely maid who gleaned in fields or skies. Okay, so how many people think that number 1 was written by William Shakespeare? How many people think number 2 was written by William Shakespeare? Okay, there's a lot of undecideds, but mostly number 2 Shakespeare. No, number 1 was written by Shakespeare. Number 2 was written by the computer. So the point is, it's not enough to have the person who created this cool poem software on the witness stand. You need to understand, the computer's the one who wrote that poem. And they're the ones we need to delve into the computer's brain, so to speak, metaphorically. Okay, you could also ask a different computer. You know, if you're Hillary's lawyer and star mix looks bad, you could ask true allele. And you don't always have the money to do that or whatnot. But in the texting example, the defense expert looked at 4 different algorithms that all came to the same result. Okay, final thing is jury instructions. The folks at the DC Public Defender Service are doing a star mix case right now. And they're trying to point out to the jury that it's possible that even though the likelihood ratio that is spit out by the computer looks bad for the defendant, 10 million times more likely that it's the defendant than a random person, if you looked at the other possible profiles of other theoretical people, their likelihood ratios are even worse, like 10 billion. And so even though if you only look at the person who happens to be in the orange jumpsuit at defense counsel table, it looks bad for them, there's a lot of other people who look a lot guiltier than this person. Why are we not looking at them? Where were they at the time of the offense? So the DC folks, number 1, are working with experts to try to figure out what the likelihood ratios for all those other profiles are. I think of that as the jinx of the machine. And giving the jury some type of instruction that would explain to them, ladies and gentlemen, you've heard evidence from a computer that Mr. Jones is a contributor to the DNA mixture based on something called a likelihood ratio. The higher the likelihood ratio, the stronger the evidence. You should be aware that the computer found other profiles that actually had higher likelihood ratios, blah, blah, blah. Now, you may be shut down, but at the very least, it will create an appellate issue if you think that you have a non-frivolous basis for such an instruction. The postscript being that Mr. Hillary was acquitted. I don't know whether he's factually guilty of the offense, but if, I think it was atmospherically helpful that those true allele results went the other way. And the concern is that in another case like Hillary, where all you have is star mix, you really have to work from scratch and be creative about these concepts to make sure that the jury gets an accurate sense of what's going on. Bottom line, don't be intimidated by the machines, but don't blindly trust them either. All right, so I think we have 11 minutes for questions. Yes, they start out with the data that is sent to them by the crime lab that is essentially, the graph with the peaks and not the sample itself. So you could take that same data on the disk that you're going to ask for, get the underlying raw data, don't just get, the printout, and then you could send it to another company. Or you could try the crime lab. And Megan, can you raise your hand? Megan's actually here this morning. Megan has been instrumental in helping to create a template motion, Dalbert Fry motion for star mix that could be used by public defender agencies around the country. The DC office is now taking the motion that Megan wrote and working with it to make it specific to DC and to their case, but we're hoping to make that template very soon available to everyone else. But if you have a star mix case, know that those are resources. Thank you.
And also, if you have a case where you're dealing with some form of AI technology or really any kind of technology that you are not sure where to begin, we encourage you to reach out to EFF. We frequently provide amicus support at the appellate level, but we have done a bunch of brief writing already that you are free to pilfer from. So please feel free to contact me via email, stephanie@eff.org, or info@eff.org if you have a case that you feel you need help with.
And EFF and EPIC have done a lot of FOIA and PRA requests for some of this internal validation stuff that's really helpful. Yeah, the quick answer for what the difference is in an offender database where you're trying to, typically you would use a database where you have no suspect and you put in a profile and you see if you get any match to a single individual. And so if you're putting in a profile, you're sort of, if it's a single, you're assuming, oh, this is the major contributor to this mixture. I can separate out this profile and see if there's any match to anyone in the database, and you get it back. If you have if you're using these types of computer programs to even interpret the mixture to begin with, the idea is I can't figure out that there's a major contributor with this particular profile. I can't even figure out how to really interpret this mixture in a way that would give us an impressive match statistic. So instead, I'm going to leave it up to the computer program, who's going to make a lot of very key assumptions about number of contributors, which things are real genetic markers or alleles and which things aren't, all that stuff. And then the differences between true allele and star mix are highly technical that we could get into, but they, one is continuous, or, one assumes a particular threshold under which things shouldn't be treated as genetic markers, and true allele says, we can interpret anything, throw it at us. So, and they claim that their system is the best. So Barry is asking, what do you do with somebody like Mark Perlin, the true allele creator, who doesn't even think that there's any need for internal validation, in part because he says, look, just throw anything at us. In a case like Hillary, that was exactly their point, was if you had looked at the stuff below, the threshold of 50, you would have seen that this guy's not guilty, or, not the source of not a contributor. If he's right that the model's just so amazingly accurate in that way, maybe it wouldn't matter what equipment the lab is using. But he also thinks that source code is completely irrelevant. And so ultimately, it's got to come back to these match scores that are being spit out by True Allele. How can he say, based on the 170,000 lines of code in True Allele, that this stuff is accurate? Not just that they generally don't tend to falsely call someone a contributor when they're not, but that the 274 million figure is accurate. And if not, if there's a margin of error, how big is the margin of error? Like, how are we going to figure that out unless we have pretty detailed information about the model, about the assumptions being made underlying the software? Everything that IEEE insists upon when we're talking about the elevator in the building. That's all we are asking for. Treat this like a human expert, where we really get to dig into the assumptions being made.